Clerk, if you would, turn around and make sure you don't have no weapon on you at all.
Of course not. We have not broken the law. I'm being arrested for obstructing government operations.
That's correct.
Attorneys Victor Revel and Megan Garcia were leaving the courthouse with their client, Lloyd Edwards, after appearing in court in reference to a protection from a order initiated by Mr. Edwards' wife, Jasmine.
Sheriff's Office?
Take a look at it.
Do you have any other weapons on your person at this time that I need to know about? RC?
No, sir.
No,
I do in the car.
Okay. What do you have in normal with?
A small pistol.
Okay. Your vehicle is also part of this search. Okay. So I'm going to have to ask you, do you have the keys to your automobile?
Yes, sir.
I need the keys to your automobile right now. Okay. Let me pat you down, make sure you don't have any other weapon. Just for your safety and ours.
Mr. Edwards was appearing in court about a protection order issued by his wife. Mrs. Edwards alleged that Mr. Edwards had abused her and their daughter, and testified that Mr. Edwards' cell phones contained proof of her claims. Mrs. Edwards' testimony led the prosecution to pursue a search warrant for Mr. Edwards' person and vehicle, specifically targeting his 3 cell phones. I called the Revel law firm, and Mr. Revel stated that there was no evidence of abuse on the phones, and that the phones actually contained evidence that supported Mr. Edwards' innocence. Mr. Revel claims that Mrs. Edwards had exchanged explicit messages with Mr. Edwards, which indicated that her interactions with him were consensual, and that he intended to submit the phones as evidence for the defense. Mr. Edwards later stated that Mr. Revel told him that, quote, "There may come a day when the prosecution wants your phone," and one of the attorneys asked him for the 2 phones just before exiting the courtroom. The phones were then placed into Mrs. Garcia's briefcase prior to exiting the building.
The warrants that you all have are for his person.
That's correct.
And for his vehicle.
That's correct.
So he is given the phone that's on his person.
Okay, I have video of him handing the phone to you, you handing the phone to her. It's in the satchel right now.
Yeah, you all do have that, but that is not on. When you all
No, I'm
came
out here
on
at the
him to
courthouse
serve
with
this
Brian on
warrant,
the search
that was
warrant.
not on his person. So you all are not entitled to that.
Okay. Well, all right then. We'll go the other route to get that other phone.
As Mr. Revel mentioned, the language of the search warrant dictates that the search may be performed on Mr. Edwards' immediate person and vehicle only. Since Mr. Edwards was not in possession of the phones at the time of the warrant being served, the deputies are not entitled to them. If the deputies had acquired a search warrant for the phones themselves, then they may have had some authority to seize them. But the validity of such a search warrant would be questionable, considering that the defense also intends to submit the phones as evidence. The search warrant presented by the officers does not authorize them to search Mrs. Garcia. After realizing that Mr. Revel is refusing to comply with the search, Deputy Ashworth calls the district attorney's office for advice on how to proceed.
Standing here, we have it on video that he handed his cell phone to his attorney, one, and then handed it to another, and it's in the satchel that is right here.
Well, are we being detained?
At this moment in time,
They're not denying it. We have it on video.
I'm going to detain you until we determine the next course of action. Give me just a minute.
Well, I have this person and vehicle. Okay, we either need the phone out of the satchel, or we will have to detain you and get a search warrant to get the phone.
So you're going to okay. Well, we're not going to give you we're not going to give you anything that's on our person that you don't have a right to. So if you detain us, you have to have certain constitutional safeguards to do that. But you're going to detain us, then hey, we're not going to run. So, and you all are telling us we are being detained. Is that right, Officer Ratt?
This point in time right now, you are being detained.
Okay, you both are under arrest for obstructing government operations.
Obstructing government operations.
That's correct.
Miss Ashworth.
This is definitely an unlawful arrest, but we're under arrest.
Mr. Revel is more than correct that this arrest is unlawful. Not only are the deputies charging Mr. Revel under the authority of an irrelevant search warrant, but neither Mr. Revel or Mrs. Garcia did anything that would constitute a violation of Alabama Code 13A-10-2. The code states that a person commits the crime of obstructing governmental operations if, by means of intimidation, physical force, or interference, intentionally obstructs the administration of law or prevents a public servant from performing a governmental function. Neither Mr. Revel nor Mrs. Garcia conducted themselves in a manner that was intimidating, physically forceful, or interfering. They both simply stated that they would not comply with the deputies' unlawful orders. They did nothing to prevent the deputies from seizing the phone. If the deputies were so sure that the search warrant authorized them to seize the phones, then what was stopping them from taking Mrs. Garcia's bag and getting them? Certainly not Mr. Revel or Mrs. Garcia.
Sir, if you would, turn around, let me make sure you don't have no weapon on you at all.
Of course not.
Okay. Just want to make sure.
We have it on video.
We have not broken the law. So if you're arresting us, I'm being arrested for obstructing government operations.
That's correct.
Y'all want to arrest two lawyers for this charge? You sure you
Are
want to
you
do this?
subject to the law?
I am subject to the law.
Under arrest.
Okay. And this is, who are you?
I'm Sue Ashworth.
Sue Ashworth?
That's correct. And this is Brian Ratliff.
And you're arresting us under her orders?
Yes, sir.
Okay.
From the moment he's entered the courthouse, he's been under surveillance.
Yeah.
Okay? For the reasons of this search warrant. Alright? I've sitting here and watched you and him and her.
Temple, if you give me about 10 or 15 minutes, I'll be ready.
You looked up. Matter of fact, you did look up at the camera 2 or 3 times. He pulled the phone out and handed it to you. You handed it back to him. He was fooling with, I'm guessing, a password. And after a short period of time, he handed it back to you. You handed it to her. She put it in here. Okay? That is evidence for this search warrant.
And you agree with me that you all served this search warrant subsequent to that, after that, all right?
Yeah.
After we left out the building.
Yes.
The deputies failed to understand the authoritative limitations of the search warrant, and Mr. Revel and Mrs. Garcia were arrested and charged under Code 13A-10-2. The prosecution initially offered to drop the charges if Mr. Revel agreed to write a letter apologizing and admitting that the deputies did nothing wrong, but Mr. Revel rejected their offer and decided to proceed with a trial. In the ensuing criminal trial, Mr. Revel and Mrs. Garcia's defense argued that the state failed to establish the defendant's intent, and that no crime was committed because the search warrant did not authorize the search of Mr. Edwards' attorneys. The prosecution argued that they were entitled to the phones under the exigent circumstances doctrine, which is a legal precedent that allows for warrantless searches in circumstances where evidence has a high likelihood of being destroyed, such as cell phone data. During the trial, Mr. Edwards, who was still under investigation at the time, testified for the prosecution, but stated that District Attorney Casey tried to prep him in his testimony, even though she had reportedly recused herself from the case, and Mr. Edwards became a key witness for Mr. Revel's defense. Ultimately, Judge King acquitted Mr. Revel and Mrs. Garcia of all charges and stated that the deputies were wrong about the authority of the search warrant and that the defendants never physically prevented the deputies from carrying out their duties. Mr. Revel and Mrs. Garcia were forced to recuse themselves from Mr. Edwards' case after filing 2 separate federal lawsuits against Deputy Ratliff and Deputy Ashworth, as well as District Attorney Casey and the Assistant District Attorney Scott Gilliland. It is worth noting that Mr. Edwards has yet to go to trial. Nonetheless, Mr. Revel is optimistic about the case and told me that he expects to reach a settlement agreement with certain undisclosed stipulations. Overall, the deputies and district attorneys of the Blount County Sheriff's Office get an F for exaggerating the authority of a search warrant, violating Mr. Revel and Mrs. Garcia's Fourth Amendment rights, and falsely arresting them for obstruction. The phones were eventually searched by the prosecution, but they did not contain any usable evidence. And even if they had, the prosecution would not have been able to submit them as evidence in the trial against Mr. Edwards because the phones were illegally obtained. Mr. Revel gets an A+ for having the mental agility and conversational fortitude to dispute the validity of the search warrant and the courage and conviction to defend his personal liberty and stand by his defendant's rights. Mr. Revel immediately knew that the arrest was unlawful and offered the deputies multiple opportunities to reconsider.